All right. Good. I guess it's afternoon, everybody, and welcome to the semifinal round of Gladiator. First, congratulations to everybody for making it here, and congratulations to coaches, parents, and all other supporters who are here to support these great competitors. We have everybody here. We'll get started, and I'll remind everybody that when we do opening statements, you might want to put it on speaker view. If you've never done that before, mouse up to the upper right and click on view. And then when we're examining witnesses, I'd suggest going back to gallery view. So we will call the case.
Judge, can I interrupt you for a second? I actually can. Okay, there we go. Because I could see that one of our scoring judges was not on screen yet. So here she is. If Judge June, I could have you just turn your video off if you don't mind. Sorry for the interruption, Judge.
Not at all. Not at all. So let's call the case of Marks versus Sonny's Rooftop Bar. Can we get appearances of counsel starting with plaintiff?
Yes, Your Honor. Good morning. My name is William Mueller, and along with my co-counsel, Julian McGaugh.
Good afternoon, Your Honor.
Afternoon.
I represent the plaintiff in today's case.
Introductions from the defense, Your Honor.
Yes.
Good afternoon, Your Honor. My name's Jackson Kunde. Today, I represent Sonny's Rooftop Bar. I'm joined today by my co-counsel, Ms. Stinson.
Good afternoon, Your Honor.
Good afternoon.
Now, while you won't be hearing or seeing much of Ms. Stinson today, she'll be assisting me with technology and timekeeping. That concludes our introductions.
Thank you. And do we have any preliminary matters from the plaintiff?
Yes, Your Honor. Firstly, we'd like to invoke Rules 615 and 603, which call for the constructive sequestration and swearing in of witnesses.
And that's
one point to that regard. Sonny Mehta, a witness we'll be calling today, is a party representative, so they'll be excluded from that rule.
Yes, so we'll allow Sonny Mehta as the party representative to remain in the courtroom constructively, and we will constructively exclude all other witnesses. Mr. Mueller, anything else?
Yes, Your Honor. Secondly, we'd like to draw the court's attention to stipulation 11, which states that exhibits 1, 22, and 23 are pre-admitted and may be used at any time.
So stipulated, Mr. Kunde?
We agree to that too, Your Honor.
I'll accept the stipulation. Exhibits 1, 22, and 23 are admitted.
Your Honor, we'd like to ask for permission to use Exhibit 2 in our opening statement. It's a photo of the deceased in today's case, and we have a good faith belief it's going to be introduced into evidence on our very first witness.
Any objection, Mr. Kunde?
Your Honor, we have no objection to that, provided that they lay the foundation on their first direct examination and do enter it into evidence.
That request is granted.
And lastly, Your Honor, we'd just like to get your preferences as to screen sharing an exhibit. Would you like us to ask permission first? Would you like us to just let you know when we're going to screen share something?
I think just let me know. We'll consider it just as we do with the witnesses, that the initial screen share will take place outside the presence of the jury. Once counsel lay foundation, then you can constructively publish it to the jury. You don't need to ask permission. If you want to make a note on the record to note that you are publishing it, feel free. But I would say just lay foundation, move the thing in, and we'll go forward with testimony.
Yes, Your Honor. And with that, the plaintiff is ready to proceed.
All right, and any prelims from defense?
Just one brief point, Your Honor. We'd like to note for the court that pursuant to jury instruction 14, the defense has raised an affirmative defense to prove that Ms. Marks contributed, at least in part, to her own death. And with that, we're ready to proceed to opening statement.
All right. And then just one last housekeeping thing. I don't know if you've had a chance to exchange demos. What we'll do is use a similar approach with demos, and that is you don't need to ask permission, put the demo up. If there's an objection to the demo, then we'll just take that up constructively outside the presence of the jury. Fair enough, Mr. Mueller?
Sounds good, Your Honor.
Mr. Kunde?
Certainly, Your Honor.
Outstanding. Then let's start with opening statements. And I'll again remind our jurors and spectators that you may want to switch to speaker view for opening statement.
May I proceed, Your Honor?
Yes.
May it please the court, members of the jury. They knew she was drunk, but they kept serving drinks. It's a Sunday night back in March of 2019 at a bar over in West Los Angeles. A young woman stumbles out of the bar and into the parking lot, barely able to walk in a straight line. She's drunk. For the last 3 hours, she'd been served drink after drink after drink by the defendant, Sonny's Rooftop Bar. She gets into her car, turns onto the highway, but within minutes, her car's at the bottom of a ravine. She's dead. Members of the jury, the woman that died that night is the woman in this photo, Jessica Marks. Her death was a tragedy. She was only 19. She had her whole life ahead of her. But what's most tragic is that Miss Marks's death would never have happened if not for the actions of the defendant, Sonny's Rooftop Bar. The evidence will show that they knew she was drunk, that they kept serving her drinks, and that caused her to crash. It's why we brought a claim of wrongful death against Sonny's Rooftop Bar. We have the burden of proving, by a preponderance of the evidence, that Jessica Marks was served when she was obviously intoxicated, and that the defendant's decision to serve her played a substantial role in causing her death. We're going to meet our burden. We're going to meet our burden by proving 3 simple facts. Let's take them one at a time. Fact 1, Jessica Marks was intoxicated at the bar. We're going to call Morgan Levin to the stand, a friend of Jessica's that was with her that night. She'll tell you that Miss Marks, she had all the classic signs of intoxication. Bloodshot eyes, slurred speech, stumbling around. But you won't just have to take her word for it. We're going to show you a video that was taken of Miss Marks, a video where you'll see she was obviously intoxicated. Which brings us to fact number 2. The defendant knew that Jessica Marks was intoxicated. For this, we're going to ask you to listen to the bartender's own words. You're going to learn that towards the end of the night, as Ms. Marks had more and more drinks, and as her intoxication became more and more obvious, bartenders acknowledged it. They looked to her and said, "We might need to cut this one off." But they never did. And that brings us to fact number 3. Despite knowing that Jessica Marks was drunk, the defendant kept serving drinks. The evidence will show that even after they saw how she was acting, even after they admitted that they needed to cut her off, even though they knew she was drunk, they kept serving drinks. It's as simple as that. And it's why we'll come before you at the end of today's trial and ask you to find Sonny's Rooftop Bar liable. Thank you.
Thank you, Mr. Mueller. Mr. Kunde, were you giving opening at this time or reserving?
We'd like to give opening statements at this time, Your Honor.
Anytime you're ready, sir.
She controlled her choices. It's March 24th, 2019. Jessica Marks is standing outside of her car. She's got her keys in her right hand and she pauses. She knows that she's been drinking with a friend that night, but she tells herself she's okay to drive. She gets in the car and she gets where she's going. Sonny's Rooftop Bar in Malibu. Because what the plaintiff didn't mention in their opening statement is that before Miss Marks ever stepped foot in Sonny's Rooftop Bar, before they served her so much as a drop of alcohol, Miss Marks chose to drink and she chose to drive. When she gets to that bar, she makes a set of similar choices. She's underage, but she chooses to drink. When she leaves the bar that night, her friend offers her a ride home in an Uber, but she chooses not to take it. She chose to drink, she chose to drive, but this time, when Miss Marks gets in her car, she doesn't make it. She dies. Good afternoon, members of the jury. My name is Jackson Kunde. And today I represent Sonny's Rooftop Bar. Today, the plaintiff has to prove to you two things. First, that Miss Marks was served while obviously intoxicated. And second, that over-serving contributed to her death. But they won't be able to do that today. Today, we'll call to the stand the owner of Sonny's Rooftop Bar, Sonny Mehta. She'll tell you that Miss Marks was served a reasonable number of drinks and didn't exhibit any of the symptoms of intoxication. Members of the jury, you won't just have to take her word for it. You'll see a receipt from that night. You'll be able to see which drinks Miss Marks ordered. And you'll hear that none of the other 10 or 12 customers in that bar were concerned for Miss Marks' safety. Now, the defense has also raised what's called an affirmative defense. And what that means is we're going to prove Miss Marks contributed, at least in part, to her own death. And to do that, we're going to focus on the choices Miss Marks made that night. The choices she made at the bar, the choices she made before she got to the bar, and the choices she made after. As members of the jury, as devastating as it is, Miss Marks controlled those choices. And it was those choices that contributed to her death. At the end of today's trial, I'll ask you to find Sonny's Rooftop Bar not liable. Thank you.
Thank you, Mr. Kunde. Let's start with plaintiff's evidence.
Yes, Your Honor. The plaintiff calls Morgan Levin to the stand.
And again, I'll remind people to switch over to gallery view if you want a better view of the proceedings.
Permission to proceed?
Yes.
Good afternoon, Ms. Levin.
Good afternoon.
Please introduce yourself to the members of the jury.
My name is Morgan Levin.
What do you do for a living?
Currently, I'm a full-time student at UCLA.
What are you studying?
I'm studying biology. I'm a senior this year.
Ms. Levin, I'm showing you Exhibit 2. Do you recognize the woman in this photo?
I do. That's Jessica at our high school graduation.
The plaintiff offers Exhibit 2.
Any objection?
No objection to that, Your Honor.
It's admitted.
Ms. Levin, how did you know Jessica Marks?
Well, Jessica and I had met in middle school around 2013, and we were inseparable ever since then. She was there for everything. She was there for my first boyfriend, when we took the SATs together, when we got our driver's licenses. She was always there.
When was the last time that you saw Miss Marks?
The last time I saw her was March 24th, 2019.
What happened that day?
Well, we had gone out to a bar, and when she was driving home, my Uber was right behind her, and I was on my phone or something. I looked up and I saw her car swerving, and I thought she'd be able to fix it, but it just kept swerving and it fell into a ravine.
Did Jessica Marks make it that night?
No, she didn't.
Sorry for your loss, Ms. Levin. If it's all right, I want to talk about what happened on March 24th, 2019. When did you first see Miss Marks that night?
I saw her around 6 p.m. She came to pick me up.
Did you and Miss Marks have any plans for that night?
Yes, we did. We made a pit stop at her Airbnb and then we planned to go to a bar, Sunny's Rooftop Bar.
Did you go to Sunny's Rooftop Bar? Do
Yes, we got there at around 9 p.m.
you remember what time you left?
Around 12, we stayed there for around 3 hours.
I want to talk about what happened from 9 to 12 that night. Who served you?
Sunny Mehta, the owner of the bar, was serving us that night.
Did either you or Miss Marks order any drinks from Sunny Mehta?
We did. We both ordered a couple.
Mr. McGaw, could we get Exhibit 17? Do you recognize this?
Yes, I do. That's the receipt from that night.
Does it look fair and accurate?
Yes, it does.
The plaintiff offers Exhibit 17.
Objection, Your Honor, hearsay.
May I respond, Your Honor?
Yes, Mr. Mueller, go ahead.
801D2, Your Honor. This is an admission by party opponent. As we can see at the top of the receipt, it was made by Sunny's Rooftop Bar. And in today's case, Sunny's Rooftop Bar is our party opponent.
Mr. Kunde?
Pardon me, Your Honor, we'd move our objection to lack of foundation. They haven't laid the foundation specifically to that signature at the bottom that it was Miss Levin who signed that.
Mr. Mueller?
I can ask Miss Levin if she signed it, Your Honor.
All right, go ahead.
Miss Levin, did you sign this receipt?
Yes, I did. That's my signature at the bottom.
We offer Exhibit 17.
With that foundation, Your Honor, we have no objection.
And Exhibit 17 is admitted.
Miss Levin, how many of the drinks listed on this receipt did you order?
Well, we got that bottle of wine and I had a glass of that and also a can of beer and just one green tea shot.
Were you with Miss Marks when she ordered?
Yes, I was.
Which drinks did she order?
She had around 2 to 3 glasses of wine from the bottle, 3 of the White Claw seltzers and a beer and also a green tea shot.
I want to talk about how Miss Marks was acting after having those drinks. Mr. McGaw, could we get Exhibit 10? Do you recognize this?
Yes, I do. That's a freeze frame of the video I took of Jessica that night.
Does it look fair and accurate?
Yes, it does.
The plaintiff offers Exhibit 10.
Any objection?
No objection to that, Your Honor.
10 is admitted.
Mr. McGaw, could we play the video?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Miss Levin, was Jessica acting like that just in that video or throughout the whole night?
Throughout the whole night. She got louder as the night went on. Her eyes got more red. She was slurring her words. She wasn't making much sense that night.
Miss Levin, do you remember any specific instances where Miss Marks interacted with the bartenders?
Yes, I do. There was 2 specific instances. One time the bartender, Sunny, came to give us our drinks and said, "This one better not be driving home." And one time, Jessica was walking down the stairs and she stumbled into one of Sunny and he said, "We better cut this one off."
After the bartender said that, did they cut Jessica off?
No, they didn't. We ended that night with a green tea shot.
Miss Levin, I want to be very clear for the members of the jury. After the bartender said we might need to cut this one off, did they serve more drinks?
Yes, they did.
Thank you, Miss Levin. Your Honor, I have no further questions at this time.
Thank you, Mr. Mueller. Cross-examination, Mr. Kunde?
Yes, Your Honor. Good afternoon, Ms. Levin. Can you hear and see me all right?
Yes, I can.
All right. I want to ask you a couple of questions about March 24th. Now, on direct examination, you told us you went to Miss Marks's Airbnb that night.
That's correct. We did.
Right. I want to talk about something you didn't actually mention on direct examination. When you got to her Airbnb, you saw that there were 2 bottles of wine on the table, right?
Yes, there were.
Miss Marks, she posted a photo of those 2 bottles of wine. Do I have that right?
Yes, she did. I'm not sure if she had had one of those bottles of wine before I got there.
Ms. Stinson, can we get Exhibit 5 up for Miss Levin? Miss Levin, this is a fair and accurate depiction of the photo Miss Marks took that night, correct?
Yes, it is.
At this time, we offer Exhibit 5 into evidence.
Any objection?
I apologize, Your Honor, without objection.
Is that admitted, Your Honor?
I'm sorry. Yes, it's admitted. Sometimes I forget to unmute myself. Thank you, Mr. Kunde.
Of course, Your Honor. Now, Miss Levin, before Miss Marks ever got to Sonny's rooftop bar, she chose to drink, right?
I only saw her have 1 glass of wine, but yes,
Right. And then she drove the 2 of you to that bar, correct?
that's correct. Yes.
Right. I want to talk about whether or not Miss Marks was intoxicated at that bar. Now, you were dining up on the patio that night, right?
Yes, we were.
Right. And there were 10 or 12 other customers around you.
Yes, that sounds about right.
Miss Levin, none of those customers ever told you that Miss Marks should stop drinking, right?
No, they didn't. We weren't really interacting with the other customers that night.
Right. None of those customers ever expressed any concern to you about Miss Marks's behavior, right?
No, they didn't.
Miss Levin, you never told Miss Marks she should stop drinking, correct?
No, I didn't. I did not.
You knew she was planning on driving home that night. You never took her keys.
No, but I did ask her to get into that Uber with me.
All right. Let's talk about the decisions Miss Marks made at that bar. She ordered all of her own drinks, right?
Yes, that's correct.
Right. There was no one else ordering for her.
No, there wasn't.
All right. And now, when you left the bar that night, you took an Uber home, correct?
Yes, I did.
Right. You insisted that Miss Marks join you in that Uber, right?
I did. I tried to get her to sit in the Uber with me, but she didn't.
Right. She refused.
That's correct. Yes.
She told you that she was fine, correct?
That's correct. Yes.
She told you that she'd gotten pretty good at driving on a big night.
That's what she said. Yes.
So when Miss Marks was offered the choice to take an Uber home with you, she drove, correct?
Yes, she did. And shortly after that, and being served drinks at the bar, her car, it fell into the ravine.
I'm sorry for your loss, Miss Levin. Thank you for your testimony today. No further questions at this time.
Thank you, Mr. Kunde. Redirect.
Yes, Your Honor. Ms. Levin, Mr. Kunde asked you about the drinks that Jessica Marks had before going to Sonny's rooftop bar. So I want to be clear. How many drinks did she have before going to the bar?
Objection, Your Honor. The question calls for speculation.
May I respond, Your Honor?
Yes.
I'm asking the witness about things that opposing counsel brought up on cross-examination, that she had drinks at her Airbnb.
No, pardon me, Your Honor. I don't mean to cut you off.
No, I don't think that was the basis of the objection, Mr. Mueller. I think it had to do with the framing of the question as how many drinks the decedent had had, as opposed to how many drinks this witness observed the decedent had had before they went to the bar. So if you want to rephrase, I'm going to sustain the objection.
Yes, Your Honor. Ms. Levin, how many drinks did you see Jessica Marks have at the Airbnb?
I only saw her have around 1 to 2 glasses of wine. That's about it.
how many drinks was she served at Sunny's rooftop bar?
I want to say around 7 that night, all of them by Sunny Mehta.
Thank you, Ms. Levin. Nothing further.
Any further questioning from defense?
No recross examination, Your Honor.
Ms. Levin, thank you so much for your testimony. You can step down. Any further evidence from plaintiff?
Yes, Your Honor. Before we rest our case in chief, we'd just like to read 2 small portions of one of those admitted exhibits, onto the record.
Of course.
In California, it is illegal to drive with a BAC of 0.08 and illegal for someone younger than 21 to drive with a BAC of 0.01. Based on all of this, I determined to a reasonable degree of professional certainty that the cause of this accident was driving under the influence of alcohol. Thank you, Mr. McGaw. You can take that down. And with that, Your Honor, we rest our case in chief.
Thank you, Mr. Mueller. And Mr. Kunde, your first witness.
Yes, Your Honor. At this time, the defense calls Sunny Mehta to the witness stand.
Anytime you're ready, sir.
Yes, Your Honor. Good afternoon, Ms. Mehta.
Good afternoon.
Could you please introduce yourself to the court?
Hi, my name is Sunny Mehta.
Now, what do you do for a living, Ms. Mehta?
Well, currently my husband Jeffrey and I are planning to move over to the French countryside, so I'm just kind of packing our things up right now.
Ms. Mehta, I have to ask, why are you here today?
I'm here because the bar I used to own, Sunny's Rooftop Bar, one of our customers a few years ago, she came to our bar and then she got in an accident.
I want to talk about that incident. What was that customer's name?
Her name was Jessica Marks.
And when did you first meet Miss Marks?
It was March 24th, 2019. She came into the bar about 9 p.m. that night.
Was anyone else at that bar with her?
Yes, she was there with her friend, Morgan Levin.
Right. I want to talk about what the two of them drank that night. Ms. Stinson-Guia, Exhibit 17 up is already in evidence. Now, looking at this receipt, can you list out what the two of them ordered?
Well, there was a bottle of wine. That's the first thing on there. Some chips and guac, and then 7 individual drinks on top of that.
Now, how many of those drinks would you say Miss Marks ordered?
Well, Miss Marks seemed to be ordering about the same number as Miss Levin, so 4, maybe 5.
All right. How long was she at your bar for?
They got there at 9. They left about 11:45 that night, so just under 3 hours then.
All right. 5 drinks over the course of 3 hours. How many drinks per hour would you say that is?
That would be 1 to 2 drinks per hour, not a ton by any means.
Now, I want to shift to something we heard in court today. Did you hear Miss Levin say that Miss Marks stumbled down the stairs that night?
Yeah, I heard her say that.
Miss Mehta, let me ask, did that ever happen?
No, it did not happen.
Did you ever say, we need to cut this one off, referring to Miss Marks?
Certainly not. If I'd thought she needed to be cut off, I would have just done so.
All right. Let's talk about whether or not Miss Marks was intoxicated in your bar. Miss Mehta, do people drink in your bar?
Yes, we would have gone out of business very quickly if they didn't.
Now, how do you recognize when someone's had too much to drink?
Well, I look for just some general symptoms and signs. Loud voice, slurred speech, stumbling, in extreme cases if someone looks like they're nauseous or passing out.
Do you have any formal training to identify those symptoms you just told us?
Yes, I took a training course actually for that purpose when I was a bartender.
All right. And now when you've recognized that someone's had too much to drink, what do you do?
I cut them off immediately, no questions asked.
Did you cut Miss Marks off that night?
No, there was never any reason to.
Right. Now, Miss Mehta, were you here for opening statements?
I was, yeah.
So you heard the plaintiff tell us that Miss Marks stumbled out of your bar and onto the street. Did you hear that?
Yeah, I heard that.
Miss Mehta, let me ask, did that ever happen?
Not even anything close to that happened.
Were you watching Miss Marks as she came down your stairs?
Yes, I was. I like to watch my customers when they're going downstairs. Sometimes people, if they've had too much to drink, will have a lot of issue getting down them.
And when Miss Marks left your bar that night, were you concerned for her safety?
No, I wasn't. I looked for the symptoms, every time I was at their table or they got drinks, and I never saw even one of them. I mean, you almost wish that she had shown symptoms, so I would have known that maybe she could be cut off, but she never showed them.
Thank you, Miss Mehta. Your Honor, I have no further questions at this time.
Cross-examination, Mr. Mueller?
Yes, Your Honor. May I proceed?
Yes.
Good afternoon, Ms. Mehta.
Good afternoon.
Ms. Mehta, it's your claim that Jessica Marks never looked intoxicated when you served her, right?
That's correct. She never showed any signs of intoxication.
It's your claim to this jury that when she left your bar, she was sober.
Well, not like sober, like she looked sober. She didn't show any signs, any reason for me to be concerned, those things.
In fact, Ms. Mehta, it's your claim to this jury that Jessica Marks looked just as sober walking out of your bar as she did when she came in, right?
That's true.
Let's explore those claims. Now, you served Jessica Marks's table for almost 3 hours, right?
Yeah, I mean, not constantly, but I was there a few times.
You served them almost $100 worth of alcohol.
I did.
Objection, Your Honor, relevance?
May I respond, Your Honor?
Yes.
We're demonstrating the sheer volume of the drinks that Ms. Mehta ordered, and that's certainly relevant as we're claiming that she was intoxicated at the bar.
May I respond to
Kunde?
that, Your Honor? Yes,
Yes.
Your Honor. The price of that alcohol doesn't constitute a number. You can buy a very expensive bottle of wine that's $200. That doesn't mean it's more alcohol than a couple of shots that are $1 each.
I agree, but there wasn't a $100 bottle of wine on this receipt. I think it was a $20 or $30 bottle of wine and a number of other drinks. Objections overruled.
Yes, Your Honor.
Ms. Mehta, you served their table almost $100 worth of alcohol.
I did, although I'll admit our prices, we tended to make them pretty high for our profit margins.
You served 2 beers,
Yes,
2 shots,
yes,
3 cans of hard seltzer,
I did.
and an entire bottle of wine.
Yeah,
You know that Ms. Marks ordered half those drinks?
yeah, I saw her with half of them.
And earlier you heard Ms. Levin say that she had more than half.
I heard her say that, but that's certainly not what I saw that night.
So Ms. Mehta, it's your claim to this jury that after serving her all those drinks, she looked completely sober walking out of your bar?
She never showed any symptoms. I looked and looked, I want to check in on my customers. They just weren't there.
Let's talk about whether there's evidence that she was drunk that night. And you know what blood alcohol content, or BAC, is, right?
I do.
It's a measurement of how much alcohol a person has in their system.
Yes,
Mr. McGaugh, could we get Exhibit 22? You know that Ms. Marks's BAC was tested after the crash, right?
yeah, I am.
You know that her BAC was 0.16?
Objection, Your Honor. We have a 104B conditional relevance issue with this evidence. May I be heard?
Yes.
Your Honor, this evidence is only relevant if they can show that Miss Mehta knew Miss Marks's BAC at the time when she was in that bar, That's frankly not true. That wouldn't go towards obvious intoxication, which is what the plaintiff has to prove today.
Mr. Mueller?
Yes, Your Honor. Part of what we have to prove is that Jessica Marks was intoxicated that night. The fact that she had a BAC of 0.16 shows that she was intoxicated and makes it more likely that she would have been intoxicated in the bar.
I agree with your points, Mr. Mueller. I guess my question is, if this witness was unaware of the blood draw and the blood alcohol content, because presumably it was taken from what I can see in Exhibit 22 after the blood draw, in terms of the cross-examination of this witness, how is it relevant?
Your Honor, it's relevant because the defense is claiming, Ms. Mehta is claiming that Jessica Marks wasn't intoxicated. She said on direct and again on cross-examination a moment ago that she was completely sober. The fact that she had a BAC of 0.16 and was that intoxicated goes directly to contest the claims that she's made.
I agree. I will let you argue that to the jury, but in terms of asking this witness, who does not seem to have a forensic background, about the significance of a blood alcohol content examination that took place at the autopsy, of which she would have no personal knowledge, I don't see that as being conditionally relevant under 104B, because this witness has no basis upon which to make a lay or expert opinion as to how that 0.16 would play into her lay observations or minimally trained observations of the decedent's demeanor and manner at the time that she was at the bar. So again, you're free to argue it. This evidence is in, but in terms of cross-examining this witness about it, I'm sustaining the objection.
Understood, Your Honor. Ms. Mehta, I want to circle back to your claim that Jessica Marks looked completely sober when she left the bar. Mr. McGaugh, could we get Exhibit 20? You recognize this as a map of the area outside your bar, don't you?
Yes,
It looks fair and accurate.
it does.
The plaintiff offers Exhibit 20.
Any objection?
Pursuant to stipulation, we have no objection to that, Your Honor.
20 is admitted.
Ms. Mehta, on the left side of the map, you see the purple marker, don't you?
Yes, that's my bar overlooking the river.
And on the right side of the map, you see the yellow marker, right?
I do.
You know, that's where Ms. Marks crashed.
Yeah,
Ms. Mehta, she crashed on the road just outside your bar, right?
not terribly far, that's true.
She crashed her car after leaving your bar, right?
She did.
Thank you, Ms. Mehta. Nothing further.
Redirect?
No, redirect your examination, Your Honor. May Ms. Mehta be excused?
Yes, Ms. Mehta, thank you so much. You can step down. Any further evidence from defense?
Nothing further, Your Honor. At this time, the defense rests their case.
And do either of our advocates need a break before we go to closing?
I don't need a break, Your Honor.
The defense is ready to proceed as well.
Any of our jurors need a break before we get to closing argument?
I'm good, Your Honor.
All right, and I don't hear anybody saying yes, so we'll go straight to closing argument. Mr. Mueller, and again, I'll remind our viewers and jurors, you may want to switch over to speaker view.
May I proceed, Your Honor?
Yes.
May it please the court, members of the jury. They knew she was drunk, but they kept serving drinks. 16 times the legal limit. On March 24th, 2019, when Jessica Marks stumbled out of the defendant's bar, the amount of alcohol in her system was 16 times the legal limit for her age. 16 times. Now, the defense, they tried to tell you that Jessica Marks just didn't look intoxicated when she left the bar. Members of the jury, a 19-year-old girl who was at the defendant's bar for as long as she was, who was served as many drinks as she was, who had a blood alcohol content of 16 times the legal limit, is going to look drunk whether they deny it or not. They knew she was drunk, but they kept serving drinks. Of course, we couldn't just tell you that. We had to prove it. We had to prove our claim of wrongful death by a preponderance of the evidence, meaning more likely than not. We had to prove, almost everything we had to prove went undisputed. There's no dispute that Jessica Marks was a minor. And there's no dispute that the alcohol in her system caused her to crash. The only question today is whether or not Jessica Marks was obviously intoxicated when they served her. We've proven that she was. And we've proven it by proving 3 simple facts. Let's take them one at a time. First, Jessica Marks was intoxicated at the defendant's bar. We called Morgan Levin to the stand, a friend of Jessica's that was with her that night. Ms. Levin told us that Jessica was drunk, told us that she had bloodshot eyes, that she was slurring her words, that she was stumbling around the bar. But you didn't just have to take her word for it. We showed you this video of Ms. Marks. Members of the jury, this video is absolutely crucial to our understanding of what happened that night. This case, it's about how Ms. Marks was acting at the bar. Was she drunk or was she sober? And we don't have to guess. We don't have to speculate because we literally have a video from that night. We can see for ourselves that she was intoxicated. Which brings us to fact number 2. The defendant saw that Jessica Marks was intoxicated. Sonny Mehta took the stand and swore up and down that even after serving 2 beers, 2 shots, 3 cans of hard seltzer, and an entire bottle of wine, Jessica just looked completely sober. But we know that's not true. We know it's not true because of Sonny Mehta's own words. We might need to cut this one off. Those aren't the words of a bartender that had no idea their customer was drunk. They're the words of a bartender that knew, but just didn't do anything about it. And that brings us to fact number 3. Despite knowing that Jessica Marks was drunk, the defendant kept serving drinks. First off, we acknowledge that the defense is claiming that they just didn't see signs of intoxication in Ms. Marks. But here's where it's so important to understand our burden of proof. We don't have to show you a confession from the bartenders because they're never going to admit that they overserved a minor. We just have to prove that it's more likely true than not that they did. So what's more likely? That after having all those drinks, after seeing how she was acting in the video with a blood alcohol content of 0.16, she didn't look drunk? Or is it more likely that she did? Members of the jury, I'll submit to you that it's far more likely that she looked drunk. Members of the jury, this is the jury verdict form. Because we've proven those 3 facts, for question 1, which asks if we've met our burden of proof, you can check the box for yes. Now the defense, they tried to point the finger at Jessica Marks. They said it was her choices that caused her death. But their argument, it just misses the point. If the bartenders did their job, if they stopped serving Jessica Marks, the second that she started showing signs of intoxication, she could choose to drive home and she would get back safe. Her choices only became dangerous. They only became fatal because of what this defendant did. So for question 2 on the verdict form, which asks if the defense met their burden, you can check the box for no. Members of the jury, what makes this case so tragic, it isn't just what happened to Miss Marks on March 24th, 2019. It's how easily the defendant could have stopped it. All they had to do was stop serving Miss Marks when she started showing signs of intoxication. But they didn't. They knew she was drunk, kept serving drinks, and that caused her to crash. Find them liable. Thank you.
Thank you, Mr. Mueller. Mr. Kunde.
Yes, Your Honor. She controlled her choices. Jessica Marks is standing outside of Sonny's rooftop bar. And there's an Uber in front of her, but she refuses to get in. She tells her friend that she's fine, that she's gotten pretty good at driving on a big night. Members of the jury, those are the words of someone in control. Miss Marks, she makes the last of a series of choices. She turns away from that Uber, she gets in her car, and she drives. Miss Marks controlled those choices. And it was those choices that contributed to her death. Let's take a step back. Because before we consider whether or not Miss Marks contributed to her own death, we have to ask, has the plaintiff met their burden? Today, they had to prove to you 2 things. That Miss Marks was served while obviously intoxicated, and that over-serving contributed to her death. But they couldn't prove that employees of Sonny's rooftop bar saw that obvious intoxication. Today, you heard from Sonny Mehta. She's someone who's been trained to identify the symptoms of dangerous levels of intoxication. Someone who sees obviously intoxicated people in her bar. And she told you, Miss Marks was not obviously intoxicated. Now, today, the plaintiff talked a lot about a video they showed you. And I want to clarify what the standard is in today's case. The standard is obvious intoxication. Whether or not a reasonable person in Miss Mehta's shoes would have seen that Miss Marks was drunk. Not if Miss Marks was drunk in that bar at any point, whether an employee should have seen that. Now, you heard today that Miss Marks, she wasn't around when that video was filmed. They told you that she was acting the same way in that video as she was in front of bar employees. But Miss Marks was a minor in that bar, fully aware she was drinking illegally. Wouldn't she have every reason to want to conceal her intoxication from bar employees? The plaintiff's case relies on things that didn't happen. That Miss Marks stumbled out of the bar, you heard today that never happened. That she was served drink after drink after drink. You heard she was served 4 to 5 drinks over the course of 3 hours. You heard that she fell down the stairs and into Sonny Mehta. Sonny Mehta said that never happened. The only person who could confirm that testimony was Morgan Levin herself, the plaintiff's own witness, someone who was drinking in that bar. Members of the jury, in hindsight, it's easy to say that Miss Marks wasn't fit to drive. We know that now. But to the people in that bar, Not a single one of them was concerned for Miss Marks's safety. Not the other employees, not the Uber driver, not Miss Levin herself. No. The plaintiff hasn't met their burden. And if you agree, your assessment stops here. You don't need to look any further. But for a moment, say you disagree. Then we have to ask you to consider the affirmative defense, whether Miss Marks's own choices contributed to her death. And to do that, we're not just going to ask you to look at the 3 hours she's in that bar. We're going to ask you to look at the full picture. The decisions Miss Marks made before she got to the bar, the decisions she made at the bar, and the decisions she made after. Let's start here. You learned today that before Miss Marks ever stepped foot in Sonny's rooftop bar, she chose to drink. And after drinking, she chose to drive to that bar. When she got to that bar, knowing she was underage, she chose to drink again. And at the end of that night, she was offered a final choice, a ride home in an Uber, a chance to get home safely. And she chose not to take it. She chose to get in her car. She controlled those choices, and it was those choices that contributed to her death. Members of the jury, no one's saying Miss Marks was a bad person. She was a teenager, and she lost her life when she shouldn't have. But the devastation we feel when we look at the circumstances surrounding her death, it can't be a reason to turn from the truth. Jessica Marks controlled her own choices. Find Sonny's rooftop bar not liable. Thank you.
Thank you, Mr. Kunde. And I believe there is some time left for rebuttal. Mr. Mueller.
Yes, Your Honor. Sonny's rooftop bar controlled their choices. They chose to serve a minor. They chose to serve that minor drink after drink after drink for 3 hours, and they chose to let that minor get behind the wheel of a car. Don't let the defense blame Miss Marks for a death that they caused. Find them liable. Thank you.
Thank you, Mr. Mueller. All right, we will give our scorers